Judges from the Supreme Court on down have been up to no good.
Supreme Court Justices Clarence Thomas and Samuel Alito are disclosing trips they took that others paid for.
Crow paid for Thomas's grandnephew to attend private boarding schools to the tune of potentially $150,000.
It's not plausible that he didn't know that these were disclosable.
About the excuses and the reasons for flying MAGA battle flags over the house of a Supreme Court justice? You cannot say that those flags did not appear.
Last month, it was revealed that insurrectionist-affiliated flags have been spotted outside Supreme Court Justice Samuel Alito's properties not once, but twice. Political displays are generally an ethical no-go zone for anyone in the business of unbiased judging. So the fact that two different flags associated with January 6th were flown years apart and in separate locations, both during times when Justice Alito was actively hearing January 6th cases and he refuses to recuse himself, feels extra slimy. This man has a lifetime appointment on the most powerful court in the land, and he knows that we know there's nothing we can do about it. But it's not just Alito, and it's not just Justice Clarence Thomas, whose wife literally helped orchestrate the insurrection, allegedly. Trump appointed a whole generation of young conservative judges who seem to revel in violating even the most basic expectations of their position. And while they're definitely some of the worst judges in recent memory, they're not the only bad apples in history. Today, we're talking about how judges use their power to undermine the will of the people. Why do they have so much power to fuck around while we're the ones who have to find out? How did we come to expect such moral cleanliness from a bunch of former lawyers? Judges are just lawyers in robes. You know that, right? And is there anything that we can do to stop them? This is how shady judges destroy democracy. Roll the intro. Thank you to my partner on today's video, 𝗬𝗢. I was diagnosed with ADHD last year, and one side effect that I find particularly challenging is the fact that I cannot turn my brain off at night when I'm trying to go to sleep. That constant rumination keeps me awake too late or wakes me up in the middle of the night and keeps me from sleeping. And when I don't get enough sleep, boy howdy, I'm a nightmare. I can't function. I'm more emotional. I eat a ton of sugar and caffeine to try to compensate for how tired I am, which just ends up making me feel worse, and I hate it. So sleep is a huge priority for me, so I can wake up feeling my best and continue to deliver you this excellent content. And that's why I love 𝗬𝗢's Dream Powder. Dream is a cup of healthy hot cocoa formulated with things like reishi, magnesium, L-theanine, and melatonin that help you get your best night's sleep. I love the original cinnamon cocoa flavor, and the chocolate peanut butter is also a fun treat. And with no added sugar and only 15 calories, I can drink it right before bed without it spiking my glucose levels and keeping me up. But it's also delicious, and I love a little sweet treat right before bed. I genuinely fall asleep faster when I drink 𝗬𝗢, which helps so much with getting the rest I need to wake up feeling refreshed and not groggy. With more sleep, I notice more balance in my mood, and I'm generally happier and less stressed, which is amazing. And I know it's summer, so a hot bevy right before bed isn't always the move. Instead, you can try 𝗬𝗢's Dream capsules, or what I like to do is add it to some ice-cold almond milk. One scoop of 𝗬𝗢 Dream is clinically shown to help you fall asleep faster, sleep through the night, and wake up refreshed. Click the link below or scan the QR code to get up to 35% off at checkout with my exclusive discount. Thanks, 𝗬𝗢. On January 17, 2021, an upside-down American flag was seen hanging outside the Virginia residence of Supreme Court Justice Samuel Alito. 11 days after election deniers had stormed the Capitol, and 3 days before President Biden's inauguration, a symbol that had become heavily associated with the Stop the Steal movement flew outside the personal home of a Supreme Court justice, while he was at work deciding whether a 2020 election case would be heard. But Alito denied the connection, saying his wife was the one responsible for raising the inverted flag. He had nothing to do with it. And anyway, it's not that deep. It was just a heated political tiff with the neighbors. Plus, who is he, Samuel Alito, to tell his wife what to do? He respects her ability to make her own choices. Unless she is with child, then fuck her, all bets are off. And it's not like he didn't realize people were paying attention. He told the story about his wife fighting with the neighbors to a Washington Post reporter in 2021. Even though they didn't publish it at the time, he knew his flags were on people's radar, and yet he went ahead and hung another insurrection insurrectionist flag at a separate property he owns in New Jersey 2 years later. The audacity is maddening. We'll talk more at the end about how Alito and some of his Supreme Court colleagues have been making a straight-up mockery of justice through various actions perpetrated both on and off the clock over dozens of years. But first, I want to look at a few of Trump's actual appointees because these are the chaos goblins we're not accustomed to hearing about so often. Good or bad, we'll always know what SCOTUS is up to because its rulings give the final word on how our national constitution is interpreted, and they're generally pretty conspicuous. Keeping tabs on lower courts because they can't stop churning out opinions legal experts say would get them a failing grade in law school, that's a newer phenomenon. Judge Aileen Cannon is the Trump-appointed federal district court judge overseeing the former president's classified documents trial in Florida, and she gives us an ideal case study to examine just how easy it is for justice to be corrupted by the people tasked with upholding it. Judge Cannon's name first hit national news in 2022, just 2 years after she was first appointed to the bench by Trump. After the FBI executed its search warrant for missing classified documents at Mar-a-Lago in August that year, Trump filed a lawsuit against the federal government requesting the appointment of a special master to review evidence seized at Mar-a-Lago to make determinations about privileges and immunity, suggesting the DOJ couldn't be trusted to do its own review. Judge Cannon obliged, pausing the investigation and appointing Trump's choice to lead the review. That is, until the 11th Circuit Court of Appeals reversed her order, condemning her decision in uncommonly scathing terms and saying her ruling violated bedrock separation of powers limitations in interfering with an executive branch criminal investigation. Thanks to the higher court, the government's document hoarding case against the former president proceeded, then landed right back on Judge Cannon's desk. When she first caught the case, legal experts feared that Cannon's previous favoritism towards the defendant would lead her to stack the jury with Trump supporters. But the way things have been going, we may never even make it to jury selection. Judge Cannon has pulled off some Olympic-level delay tactics throughout this process, taking her sweet, sweet time to parse each and every motion, no matter how absurd, to run down the clock. Trump is aiming to delay as many trials as possible until after the election, because if he wins in November, he can pardon himself and those charges will just disappear. If you're interested in my reaction to the verdict in the only Trump trial we're probably getting before the election, the New York hush money case, check out my recent video after this. Judge Cannon has done everything in her power to make Trump's wish come true, slow walking her way through each and every motion, no matter how standard, providing very little insight into her legal reasoning when she does issue a ruling, and generally seeming unsure and inexperienced, until on May 7th, 2024, she postponed the trial indefinitely, citing the large backlog of motions still waiting to be processed. The case is delayed because she caused the delays. Great. In the week after she announced the postponement, Judge Cannon was the target of over 1,000 complaints as to her conduct. That's really not the right way to get a judge off a case, but we'll talk about that. Early on in this case, as Judge Cannon's slow and steady approach was unfolding, some gave her the benefit of the doubt, attributing the pace to her inexperience and a desire to make sure every I was dotted and T crossed. After all, as of June 2023, she had only heard 4 criminal cases, and fairly straightforward ones at that. None lasted more than 3 days in court. But by the time Judge Cannon indefinitely postponed the trial, the bias behind her behavior was undeniable. Yes, cases involving top-secret documents are complicated. No, it wasn't reasonable for Judge Cannon to spend 7 weeks deciding whether or not Trump's groundskeeper should get to see classified content that has no bearing on his defense. For the most part, Judge Cannon's decisions have been sensible. They've just taken her an obscenely long time to make. A notable exception being her quick refusal last month to grant a gag order barring Trump from continuing to make false claims that the FBI agents who raided Mar-a-Lago were part of an assassination plot. In reality, the FBI agents were operating under standard protocol, which does include a provision that they're allowed to use deadly force if necessary, but that's really different from a shoot-to-kill order. And given all the civilians who actually die at the hands of law enforcement every year, having a former president play on that fear, even though he wasn't even in the state of Florida, let alone on site during the raid, and he has round-the-clock Secret Service protection unlike the rest of us who have to just raw dog it out here among America's 393 million guns, is pretty disgusting. Special counsel and our special channel daddy, Jack Smith, renewed his calls for the gag order, and Judge Cannon has given Trump's team until June 14th to respond. Trump's team has called Judge Cannon a godsend, implying that divine intervention and not careful political planning orchestrated the outcome. When Judge Cannon was confirmed to her post in November 2020, it was under a new precedent the Senate had established the previous year that lowered the maximum time permitted to debate nominations below cabinet level from 30 hours to 2. 2. It also allowed a candidate to be confirmed with only 51 votes instead of the traditional 60-vote threshold. So when the Senate confirmed Cannon by a vote of 56 to 21, she was in for life. At the time of her appointment, Judge Cannon was just 39 years old, more than a decade younger than the average age for new appointees in her position. She just barely met the required 12 years of legal practice necessary to qualify for the bench. She had served at least 7 years as an assistant U.S. attorney for the Southern District of Florida, but perhaps most importantly, she clerked for Judge Stephen Callahan of the 8th Circuit U.S. Court of Appeals, who was once on Trump's Supreme Court nomination list. Experts have speculated that this connection, plus her ties to the conservative legal advocacy group the Federalist Society, sealed her spot on the bench. So that's how Cannon ended up a federal judge, but how did someone so inexperienced and biased wind up in charge of a former president's very complicated documents case? Judge Cannon is one of 26 judges who can be randomly selected to adjudicate any criminal case that comes through the Southern District of Florida. But the chances of Judge Cannon winding up in charge of Trump's documents case weren't actually a 1 in 26 chance, it was more like a 1 in 3 chance. For administrative purposes, Florida's Southern District is divided into 5 parts: Miami, Fort Lauderdale, Palm Beach, Key West, and Fort Pierce. Cannon is the only judge in Fort Pierce, but for the purpose of assigning judges, Fort Pierce is considered part of the Palm Beach division, which only had 2 other judges eligible to take the case. According to reporting by The Hill, despite the grand jury that handed down Trump's indictment sitting in Miami because the courthouse was comfier and more convenient, an administrative order deemed the investigation a Palm Beach inquiry. But even if all 26 federal judges were potentially on the table, why would our most special prosecutor Daddy Jack Smith want this case in Florida to begin with? Trump also stored documents in Washington, D.C. and New Jersey. Why overlook those options and bring the trial to a state Trump handily won twice? Remember when I said the initial concern was jury stacking in Trump's favor? Yeah, Florida is an ideal place for that. Ultimately, experts speculate that Daddy Smith chose Florida because it was clearly the case's center of gravity. The most documents were stored there, and bringing the suit anywhere else would give the defense grounds to file a motion to change venue, which would in turn cause delays the prosecution was eager to avoid. And yet, here we are. Now, if the shoe had been on the other foot and a pro-Trump lawyer had chosen Florida, even if they only accidentally had the good fortune to stumble onto Judge Cannon's docket, it would have looked like judge shopping. Judge shopping is a tactic wherein lawyers exploit case assignment rules to ensure they end up in front of ideologically aligned judges and guarantee a favorable outcome. This strategy has become popular recently, particularly in cases with broad national implications. Many cases that have made it to the Supreme Court that don't make a lot of sense were the result of this judge shopping approach. In my video on contraception, we talked about another Trump appointee, Northern District of Texas Judge Matthew Kacsmaryk, who's become the poster child for modern judge shopping because he is so blatantly in favor of conservative causes that he's willing to literally misread the law over it. He's had multiple rulings overturned by the Supreme Court for basic misreadings of the law. And if you're thinking, isn't that a good thing? Kacsmaryk getting overturned shows that our system's checks and balances are actually working. You're right, it is a good thing, but it doesn't erase the damage bad calls can cause before they're overturned. In 2022, Kacsmaryk issued a stay on the Biden administration's effort to end a Trump-era immigration policy known as Remain in Mexico, which kept asylum seekers outside the country while their cases were being processed. The policy is unpopular among rights groups who say that keeping asylum seekers on the other side of the border puts them in unnecessary danger of being preyed upon by kidnappers and gangs. Kacsmaryk's decision was legally questionable at best, but until it was overturned by a higher court, it stood. So for nearly a year, a policy was forced on the people against even the president's wishes, all because one schmuck in Texas said so. That's a fuck ton of power. In March 2024, the Judicial Conference of the United States, one of the federal court's internal governing bodies, announced a new policy requiring lawsuits aiming to block state or federal laws to be randomly assigned throughout a federal district. But after facing pushback from conservative judges and Senate Republicans, the conference later backtracked, saying the new policy was discretionary and leaving it up to each district court to decide how to proceed. And this really begs the question, who the fuck is in charge of these people? Is there no recourse at all? Technically, Congress could wrestle back control. Several bills have been proposed to solve the judge shopping problem. The most recent, poetically entitled the Stop Judge Shopping Act, was introduced in April 2024 by Senator Chuck Schumer and requires all district judges be assigned cases randomly. But based on how well judge shopping has been going for conservatives because of the many Trump appointees out there fucking shit up, I'm skeptical that this bill will get any traction. The headline here is that our system makes it really hard for anyone to tell a judge what to do. And that's by design. A lot of the mechanisms we have in place were intended to preserve preserve the independence of good judges. Back in the day, when most people died by the age of 60, lifetime appointments seemed like a perfectly reasonable way to insulate judges from the political passions of the day. No need to be swayed by public opinion to win re-election, but also they'll only be on the bench for a couple decades and then fresh blood will take over. Today, lifetime appointments for judges can feel more like death sentences for justice, because once they're in, we're trapped, not just for a couple decades, but for a quarter to a half a century, an entire generation. Going back to the Judge Cannon situation, the 11th U.S. Circuit Court of Appeals could theoretically reassign her for engaging in conduct that gives rise to the appearance of impropriety or a lack of impartiality in the mind of a reasonable member of the public. But it's not a lever pulled often, and even if they did move Cannon off the case, the 11th Circuit Court of Appeals can't remove her entirely. Aileen Cannon gets to serve until she dies, retires, or she's impeached by the House and convicted by the Senate, which, spoiler alert, happens extremely rarely. And since she was appointed at the tender age of 39, that means that Aileen Cannon could conceivably serve on the bench for 50 years. In the over 200 years between 1803 and 2018, the House of Representatives impeached a grand total of 15 judges in all of the federal judiciary, mostly for things like making false statements, favoritism towards litigants or special appointees, intoxication on the bench, and/or the abuse of the contempt power. Only 8 of those impeachments were followed by convictions in the Senate, and the Constitution doesn't provide much guidance about what behavior is impeachable. Like other government officials, judges can be removed for treason, bribery, or other high crimes and misdemeanors. But other than that, we've just got Article 3, Section 1 telling us that judges shall hold their offices during good behavior. What's good behavior? Who knows? At the federal level, complaints against judges are ruled on by the circuit chief judge, then the Committee on Judicial Conduct if an appeal is deemed necessary. For state matters, complaints against judges are investigated by the state's Judicial Oversight Committee. Unlike appellate courts, judicial commissions can't change verdicts or order a new trial. Their job is to investigate complaints and pursue discipline ranging from reprimand to removal. And there's debate among experts about how effective these commissions are, especially in states whose commissions seem designed to shield judges from consequences. In Alabama, for example, the Judicial Inquiry Commission is comprised of 9 members, a mix of lawyers, judges, and laypeople, all appointed. The commission's deliberations are held in secret and, according to Reuters, have produced some of the most judge-friendly rules in the nation. Unlike most states, which will launch an investigation after receiving a phone or email tip, Alabama requires that complaints be submitted in writing and notarized. Anonymous complaints are simply shredded. Assuming you manage to properly file a notarized complaint, the judge in question will be informed immediately. When any witness provides a statement, the judge receives a transcript. If a subpoena is issued, the judge gets a copy. And remember, Alabama doesn't allow anonymous complaints. So pretty much immediately, the complainer is put on blast, but the judge is protected from public scrutiny until after being officially charged with misconduct. Between its inception in 1973 and the start of 2024, Alabama's Judicial Commission has filed 64 complaints for investigation in the Court of the Judiciary total. In 2023, Alabama's Judicial Inquiry Commission received 166 complaints, 154 of which were dismissed without investigation. 16 complaints were investigated and then dismissed. 3 complaints resulted in charges in the Court of the Judiciary. 2 were carried over to the next year. 3 out of 166 complaints resulted in charges. That's less than 2%. And because those complaints aren't public unless they result in actual charges, Alabamans have access to less than 2% of complaints made against the judges who will determine their fate in court. To be clear, complaints relate to a judge's conduct, not their rulings. So if a judge shows up drunk and proceeds to make a ruling that gets upheld later, implying it was a good call, the judge can still get in trouble for being drunk even though the outcome turned out okay. Conversely, a judge like Aileen Cannon can't be punished for coming to work stone cold sober and making what some would argue are shitty, biased, or unconscionably delayed decisions, but she can have those decisions struck down by higher courts. And though it's certainly not a good look to have one's rulings reversed repeatedly, judges don't accrue strikes or points or demerits of any kind for being overturned, nor are there any sort of levels distinguishing one type of overturning versus another. So even though it feels like Kaczmarek and Cannon should have some very specific type of mark against them, calling out their legally precarious decisions, in practice, those reversals are no different than any others. And it actually makes a ton of sense to prevent judges from being punished for their decisions. If we want free and fair decisions, which we claim to, it's understandable why there's no 3 overturned decisions and you're out rule for judges. That kind of rule could have a chilling effect on judges who, instead of just considering the law, would also have to consider the personal and professional consequences of their decision, even if they believe it's the correct one. Additionally, it's very common for there to simply be disagreements in the application of a law, and a judge can very earnestly and thoroughly apply the law to the case, only to be overturned by a higher court that doesn't agree with that interpretation of the law. Most laws are arguable. That's literally what lawyers do all day long. Being overturned doesn't inherently mean a ruling was bad or nefarious. It's just a system in place to ensure that there are many checks on judicial interpretation of the law. Thank you to my Patreon community and my YouTube members for supporting the research and work that goes into these videos. I love making these videos free and widely available for as many people as possible because I believe strongly in access to legal and political education. And your contributions on Patreon or YouTube membership allow me to continue bringing you this content for free week after week. To say thank you, as a member on Patreon or YouTube, you will receive early, uncensored, ad-free versions of these videos, as well as special extra content and more. Please consider joining today. In general, we give judges an enormous amount of freedom to make their decisions. Absent a fixed rule like a mandatory sentencing minimum, the judge is empowered to consider the circumstances of the specific case and choose the most fair and equitable interpretation of the law as they see it. At the federal level, judges are given sentencing guidelines which help them determine criminal penalties by laying out circumstances that should lead to longer or shorter sentences, such as the heinousness of the crime or the defendant's good behavior. While judges follow the guidelines closely, they're not legally bound by them, and the guidelines provide wide ranges for the judge to then use their own discretion to decide. Most laws lay out the maximum penalties associated with violations of the law, and some also define mandatory minimum sentences for certain crimes, and judges are bound to follow those. But even within those laws, there is leeway for the judge to determine how severe to make a sentence. And during the proceedings themselves, judges must make numerous calls on motions, objections, and requests from both parties, all of which provide the judge with broad discretion. And what they say and the rules they set for their own court must be followed by all parties, absent a successful appeal to a higher court. In the best case scenario, this freedom to make their own rulings, called judicial discretion, increases fairness. The law is subtle and almost always depends heavily on the facts of each case. Blanket rules do not adequately account for this, which is a strong argument against mandatory minimums, but that's a video for another day. However, this wide leeway for judicial discretion also gives a lot of freedom for bad apples to abuse the system. If abused, judicial discretion can undermine the court's authority, reputation, and ability to preserve justice. In 2020, a Reuters investigation of more than 5,000 cases found that between 2009 and 2019, 9 out of 10 state and local judges who abused their power kept their jobs. 90% of them kept their jobs thanks to a low transparency disciplinary system that experts say tends to err on the side of protecting the rights and reputations of judges while overlooking the impact courtroom wrongdoing has on those most affected by it. Those most affected are people like Marchiony Johnson, a single mother of 3 who was incarcerated in Alabama for 496 days for failing to pay traffic tickets. Her sentence exceeded the allowable sentence for negligent homicide, and while she struggled to survive in prison, her children were abused in foster care. When she got out, no one in the family was the same. 4 years later, the Judicial Inquiry Commission found the judge in that case, 𝗬𝗧, guilty of breaking numerous state and federal laws by jailing Marchiony Johnson and hundreds of people like her who served obscenely long sentences for the crime of being too poor to pay fines. When confronted, Judge Hayes pretended that this was news to him and that he hadn't realized he was doing anything wrong, even though other Alabama judges caught heat for doing the same thing. Judge Hayes received an 11-month unpaid suspension before being allowed to return to the bench and retire voluntarily in 2020. For a judge to actually face a criminal conviction, they have to behave so egregiously that no amount of benefit of the doubt can save them. We got an example of this in 2008 when 2 Pennsylvania judges were convicted of taking $2.8 million in kickbacks as part of a scheme to fill private juvenile detention centers. The Luzerne Kids for Cash scandal saw more than 3,500 teenagers funneled to 2 state-subsidized facilities that charged as much as $315 per child per day. 90% of the involved juveniles' records were later expunged. Then there was the 2018 incident in which Judge Jack Robinson of the 207th District Court in Texas burst into the jury room, urging the jurors to reconsider their guilty verdict because God told him the defendant was innocent. This caused a mistrial and led Texas's Judicial Commission to issue a public warning with the intent of assisting Judge Robinson in his continued judicial service, as well as a continuing effort to protect public confidence in the judicial system. A clear example of the level of concern these judicial commissions have about the reputation of the judge instead of the potential abuse by that judge of the judicial system, and especially the defendants within it. Because as I hope these stories have made clear, the people who lose the most when judges act badly tend to be criminal defendants, people who society has thrown away probably before they were even sentenced, and who are so dehumanized that the 13th Amendment against slavery makes an exception for criminals. For them, there is little recourse, even when the behavior of their judges is obviously unconscionable. For a great book on more of the way our judicial system fails the most vulnerable people in it, check out Just Mercy by Brian Stevenson. So judges have an enormous amount of power, and justice tends to be slow to catch up with them. But they're not entirely unaccountable to the public. Trial judges are the most likely to be elected as opposed to appointed, which makes sense because they interact with the greatest volume of the public. In general, partisan elections are less prevalent than nonpartisan ones, where no party information is included on the ballot. Again, we're pretty invested in the whole appearance of neutrality thing. Many states have some hybrid approach where either the governor or the legislature handles appointing a judge to their first term, but then the public gets to vote after they've served for a few years in something called a retention election. But if judicial misconduct is fastidiously hidden from public view by state commissions, it's questionable how much the public knows about a judge and their behavior on the bench when voting for them. Gubernatorial appointments are by far the most prevalent mechanism for getting judges onto the bench, and the American Bar Association wishes every state used only that mechanism. The ABA has been calling for governors to handle appointing all state judges since the 1930s. In 2003, the ABA reiterated this position and recommended that judges serve a single 15-year term, or until mandatory retirement age, with no reselection process once admitted. Arguments against electing judges include the incentives that election pressure may create for incumbent judges. This is a real problem, and research bears it out. A 2015 study by the Brennan Center found that the closer judges get to an election campaign, the more likely they are to hand out harsh sentences, including the death penalty. Over a 15-year period, appointed judges were found to reverse death sentences in 26% of capital cases, while judges facing retention elections reversed 15%, and judges in competitive elections reversed 11%. I mention all that to point out, again, how much power these judges have. They literally hold lives in their hands. And whether they're intentionally participating in a kickback scheme, or jockeying for re-election, or simply don't believe in restorative justice and think it's fine to ruin someone's life for the crime of being poor, judges at every level enjoy a ton of freedom and are enormously insulated from consequences, even as their actions rain consequences down on the rest of us. And nowhere are the stakes of that dynamic steeper than the US Supreme Court. The Supreme Court is the most visible court in the land, and its decisions impact the entire American population. So it's really concerning to see any of those 9 justices flouting their ethical responsibilities. Again, we protect judges assuming that they'll perform their duties in good faith, attempting to do what's fair, and embodying all the wisdom and self-restraint we imagine a judge should. But even when earnestly trying to do a good job, the Supreme Court has still authored its share of fucked up decisions that have had devastating consequences. Here are some notable examples. Dred Scott v. Stanford from 1856 is widely considered the worst decision the Supreme Court has ever made. Check out my video on it for details. It ruled that enslaved people weren't U.S. citizens and therefore weren't entitled to protection from the federal government or the courts. Furthermore, it stated that Congress had no authority to ban slavery from a federal territory. U.S. v. Cruikshank was a 1875 decision favoring a white supremacist mob that armed itself with guns and cannons to kill a rival black militia defending its right to self-governance. The court held that black people must look to the states to protect their civil rights to peacefully assemble despite the existence of the First Amendment. Plessy v. Ferguson from 1896 upheld racial segregation under the so-called separate but equal doctrine. Buck v. Bell from 1927 upheld forced sterilization of those with intellectual disabilities for the protection and health of the state. Korematsu v. U.S. in 1944 held that Japanese Americans could be forced into concentration camps during World War II. The majority opinion was written by Justice Hugo Black, a former member of the KKK. Bowers v. Hardwick in 1986 ruled that there were no constitutional protections for sodomy and that states could outlaw such practices as they saw fit. In Bush v. Gore in 2000, the Republican majority on the court stopped the presidential election recount, arguing that different standards for counting votes across counties could unfairly disenfranchise voters. The decision set a precedent for future election meddling by the Supreme Court. In Citizens United versus FEC in 2010, the court ruled that political donations are a form of speech protected by the First Amendment and opened the floodgates to the unprecedented political spending that has catastrophically undermined our democracy. And because of the way the decision was written, Congress would have to pass a full-blown constitutional amendment to get money out of politics at this point. And yet, despite this long and storied history of trash decision-making, the Supreme Court has generally maintained the public's trust, until recently. According to a 2023 Pew survey, only 44% of Americans view the Supreme Court favorably. Less than half. That's historically low. In fact, it's the lowest since they started tracking this kind of data in 1987. This is notable because while we don't have public approval data spanning the entire length of the Supreme Court's history, it does indicate that even when making horrible, bigoted, trash decisions in the past, saying women aren't people, saying black people aren't people, saying Japanese people can be locked up, allowing the criminalization of gay people, upholding separate but equal, saying forced sterilization is a-okay, etc., despite members of the court being literal slaveholders or former members of the KKK, despite all of this, the judges on the Supreme Court have historically at least tried to make it seem like they had respect for the institution they represented, at least tried to make it seem like they continued to be impartial arbiters of the law, at least tried to distance themselves from behavior that would even hint that they weren't impartial. That's included having family members quit their jobs, divest from certain funds, and go to great lengths to ensure that there was nothing the public could point to that made them question whether or not they could trust the decisions of the highest court of the land, even when that court was making heinous decisions. Until now. We now have public record of Supreme Court justices accepting lavish gifts from billionaires with matters before the court, and even flying flags in front of their houses in support of a literal insurrection, the alleged perpetrator of which has numerous matters pending before the court. And instead of taking the institution on which they serve seriously enough to at least pretend to care about the impropriety, these justices, Alito and Thomas specifically, who ironically aren't even Trump appointees, for all we love to scream about Trump-appointed judges, look us, the American public, directly in the eye and gaslight the fuck out of us. I don't know what you're talking about. No unbiased person would ever think that I should recuse myself. You're just biased. I'm the one who isn't biased. And anyway, what are you gonna do about it? I've already made a whole video about the fucked up Supreme Court ethics code. Don't even get me started. A 2023 analysis found that the American public has more trust in the judiciary as a whole than in the Supreme Court specifically, so all's not completely lost yet. But our trust should be earned and accounted for. While there have always been bad apples in the proverbial judicial barrel, there was a time when we could take it for granted that, for the most part, judges would behave in a sane and reasonably ethical manner. Now that we have a generation of partisan hacks violating all our expectations about how a judge should conduct themselves, we'd do well to pay a tad more attention. We talk a lot on this channel about the importance of voting, especially in local elections, and this is another one of those occasions. The Brennan Center has a tool where you can find out how judges are selected in your state. So when I go there, I can select Minnesota from the drop-down menu and find that most of our judges are chosen through nonpartisan elections. You can do this too. Find out whether you have the ability to vote on any judgeships in your state and plan to pay attention to those elections. If your state doesn't let the public get directly involved in choosing judges, you can still exert some influence. Consider the role that other elected officials, particularly your governor, will play in appointing judges. And don't forget how much is on the line in the presidential race this year. Trump appointed 226 federal judges, who we are now stuck with until they die, retire, or get convicted by Congress. The stakes of the November election really can't be overstated. There is a very real possibility that Trump wins in November and Alito and Thomas, who are both in their 70s, conveniently decide to retire. Whoever we pick has the very real potential to determine the leanings of our judiciary for the next generation. So don't fuck it up. And shout out to my newest supporters, as well as supporters in my royal tiers, and a very special shout out to my multi-platinum supporters, T, Latrange Lucas, Joshua Cole, Thomas Johnson, Sophia Sams, Anthony Giles, Tay, and Brett Piontek. Your generosity makes this channel what it is, so thank you. If you like this video, you'll also like this one about the Supreme Court Ethics Code. Thanks so much for watching. Have a good day. Bye-bye!